Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about the SEC's recent expansion to allow all companies to file draft confidential registration statements. The SEC recently expanded the ability to file confidential registration statements for all companies completing an initial public offering or secondary or follow-on offering which is completed within 12 months after a company becomes publicly reporting, and for Section 12B Exchange Act registration statements. The ability to file draft confidential registration statements was previously limited to emerging growth companies, or EGCs, or companies filing initial offering circulars for their first-time Regulation A+ offerings. Foreign private issuers may follow the new guidance. They may follow the process available to emerging growth companies if they qualify, or they may elect the confidential review process only available to foreign private issuers. In particular, the SEC allows the non-public submission of draft registration statements for foreign companies if the foreign registrant is a foreign government registering its debt securities, a foreign private issuer that is listed or is concurrently listing its securities on a non-U.S. securities exchange, a foreign private issuer that is being privatized by a foreign government, or a foreign private issuer that can demonstrate that the public filing of an initial registration statement would conflict with the laws of an applicable foreign jurisdiction. Shell companies and blank check companies may not utilize a confidential submission. If a company wants to keep certain information confidential, even after the required time to make such information public, it will need to submit two confidential requests, one as part of the registration review process, and one when prior confidential filings are made public. During the confidential review process, the company should submit a request under Rule 83 in the same manner it would during a typical review of a registered offering. Once the company is required to make the prior filings public, i.e. 15 days prior to qualification or effectiveness, the company would make a new request for confidential treatment under Rule 406 in the same manner other confidential treatment requests are submitted. In particular, for a confidential treatment request under Rules 83 and 406, a company must submit a redacted version of the document via EDGAR with the appropriate legend indicating that confidential treatment has been requested. Concurrently, the company must submit a full, unredacted paper version of the document to the SEC using the ordinary confidential treatment procedure. The filings are submitted via a designated fax line to a designated person to maintain that confidentiality. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit Securities Law Blog and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.